Good morning, everyone, and thank you for being here today. I'm excited to introduce our presentation on navigating the complexities of trust disputes from investigation to resolution. This comprehensive guide to trust and estate litigation will walk you through the key steps involved in handling these challenging cases. Over the next few slides, we'll explore everything from initial investigation to reaching a successful resolution. Let's get started. Let's take a look at the table of contents for today's presentation. First, we'll start with an introduction to trust disputes to set the stage for what we're discussing. Then, we'll walk through each phase of the process, beginning with Phase 1, Initial Information Gathering. This is where we collect all relevant facts and documents to understand the dispute thoroughly. Next, Phase 2 involves drafting of pleadings, where we prepare the legal documents that formalize our claims or defenses. Moving on to Phase 3, Discovery, which is a formal investigation process. Think of it as the exchange of information to build our case. In Phase 4, we explore alternative dispute resolution options, such as mediation or arbitration, which can sometimes resolve disputes more efficiently without going to trial. Phase 5 covers the designation of expert witnesses and depositions, where specialists are brought in to support our case and sworn statements are taken. Then Phase 6 is trial preparation, where we get everything ready for the courtroom, and Phase 7 is the trial itself, the actual courtroom showdown. Following that, Phase 8 involves the appeal process, if necessary, to challenge or defend the trial outcome. Finally, we wrap up with the conclusion and key takeaways, highlighting the most important points to remember. Throughout this presentation, I'll also be sharing how to contact Vincent M. Cassiano, Esquire, for expert legal assistance. This table of contents provides a clear roadmap of what to expect and how each phase fits into the overall process of handling trust disputes effectively. Let's take a closer look at the introduction to trust disputes. Trust and estate litigation is essentially about conflicts that arise over how estate planning documents are managed and whether they're valid. These disputes are often called will and trust disputes, and they can involve a variety of issues, from disagreements over the validity of a will to disputes about how assets are to be distributed. Understanding the nature of trust and estate litigation is really important for anyone who might find themselves involved in these conflicts. The resolution process can be quite complex, often taking a significant amount of time and resources. That's why having a clear understanding of how these disputes are resolved is so valuable. This slide also introduces the idea that this guide will walk you through the typical phases involved in trust and estate litigation. Knowing what to expect at each stage can help you navigate the process more confidently, whether you're involved in a dispute or simply want to understand how these conflicts are resolved. Throughout this presentation, I'll highlight the key points and connect them to the bigger picture of estate planning and dispute resolution. Now, let's talk about the first major phase in trust and estate litigation, the thorough investigation of claims. This initial step is all about gathering detailed information. It begins with what we call the initial information gathering. During this phase, we carefully examine any claims made or alleged against you. The goal here is to understand every aspect of the case thoroughly. To do that, you'll need to provide us with relevant documents related to the estate or trust. Additionally, we'll want a clear chronology of events to piece everything together. It's also important to gather contact details for witnesses, family members, and interested parties, people who can shed light on the situation. Now, this part of the process often requires a lot of communication. Think numerous consultations, emails, and texts. Frequent contact is key to verify and clarify all the information we collect. Depending on how complex the case is, this phase can take anywhere from a few weeks to several months. The timeline really depends on how much information we need to investigate and verify. So, the key takeaway here is that this thorough investigation is foundational. It sets the stage for everything that follows in the litigation process. Now, let's move on to Phase 2, drafting of pleadings. At this stage, it's crucial to understand the common legal claims that often come up in trust and estate litigation. These include breach of fiduciary duty, undue influence, and fraud. But it's not just limited to those. Claims might also involve elder abuse or wrongful taking of property. Recognizing these claims helps us identify the core issues in a case. Next, we have the concept of a demurrer. A demurrer is a legal tool used to challenge the sufficiency of the claims made against you. Essentially, it asks the court to dismiss the case because, even if all the facts are true, they don't amount to a valid legal claim. Filing a demurrer involves following specific technical rules, so precision is key. It's also important to remember that if you're sued, you need to respond to the legal claims. Your response can take different forms: an objection, an answer, or a demurrer, depending on the situation. Choosing the right response is vital to protecting your interests. In probate court, the parties are called the petitioner and the respondent, whereas in civil court, they are the plaintiff and the defendant. Understanding these terms helps clarify who is bringing the claim and who is defending against it. Finally, litigation officially starts when a petition or a complaint is filed. These documents outline the legal claims involved, such as breach of fiduciary duty, undue influence, fraud, elder abuse, or wrongful taking of property. Recognizing how these documents initiate the process is important for effectively navigating the early stages of a case. Now let's talk about the discovery phase, which is a formal investigation in trust and estate litigation. This part of the process can last several months, so it's not something that happens overnight. During this phase, disputes often lead to court motions, especially when one party needs to compel the other to respond to requests for information. A key component here is depositions. These are sessions where witnesses are questioned under oath. They're recorded by a court reporter, and these recordings become part of the official record. Depositions are crucial because they help us gather first-hand accounts and clarify facts. Another important tool in discovery is subpoenas. These are legal documents issued to third parties, such as banks or other institutions, to obtain relevant information they hold. Alongside subpoenas, we have requests to admit facts, which ask parties to confirm specific details under oath. This helps streamline the case by establishing certain facts early on. Written interrogatories are another part of the process. They're essentially questions exchanged between parties to gather detailed information. Additionally, document production demands require parties to provide relevant documents that could support or challenge claims. Overall, discovery is all about the formal exchange of information. It includes written questions, document requests, subpoenas, admissions, and depositions, all aimed at uncovering the facts necessary to resolve the dispute. This phase is foundational because it sets the stage for the rest of the litigation process, ensuring both sides have access to the information they need to make informed decisions. Most cases in trust and estate litigation typically reach a stage where parties consider mediation or settlement conferences before heading to trial. These sessions are usually led by experienced attorneys or retired judges who are specially trained to facilitate discussions and help parties find common ground. The goal here is to encourage a fair and mutually agreeable resolution without the need for a full trial. It's important to understand that while many disputes do settle during these sessions, parties are not required to agree. This voluntary aspect ensures that any resolution is based on mutual consent, which is often more satisfying and sustainable for everyone involved. The main aim of this phase is to resolve conflicts efficiently. By doing so, we can avoid the significant expenses and the uncertainty that typically accompany a trial. Guided by seasoned professionals, these facilitators play a crucial role. They help create an environment where compromise is possible. Their expertise is vital in helping the parties see common ground and reach resolutions that work for all sides. This process not only saves time and resources, but also aligns with the overall goal of a fair and prompt resolution in trust and estate disputes. Now, let's move on to Phase 5, expert witness designation and deposition. Expert witnesses are typically designated to support key claims. such as those involving lack of capacity or undue influence. These experts play a critical role by providing specialized opinions on issues like cognitive impairment or legal theories, which can be pivotal in the case. When it comes to expert witness designation, medical professionals often serve as these witnesses, especially in cases where mental capacity is in question. Their testimony helps establish whether the individual had the mental capacity needed at the relevant time, which is essential for supporting or challenging claims. However, it's important to recognize that bringing in expert witnesses can be costly. They require a significant financial investment, but their involvement is crucial because they provide the specialized insights necessary before the trial begins. Finally, expert witnesses are usually deposed by both sides. This process allows each party to clarify and scrutinize the expert's testimony and rationale thoroughly before the case proceeds to trial. Overall, these steps ensure that expert opinions are well understood and properly challenged, strengthening the integrity of the litigation process. Now let's talk about Phase 6, trial preparation. This stage is quite intensive and definitely requires a significant time investment. As attorneys, our goal here is to develop a compelling case theory that can stand up in court. To do that, we rely heavily on witness testimony and supporting documents, which form the backbone of our case. Preparing for trial isn't just about having the evidence, it's about organizing and mastering it all. That means going through deposition transcripts, medical records, financial documents, and discovery responses meticulously. These are crucial components because they provide the factual foundation for our arguments. It's also important to recognize just how much time this preparation takes. Typically, for every day of trial, we might spend 2 to 3 days preparing. This extensive effort ensures that we're thoroughly ready to present our case confidently and effectively in court. And at the heart of this process is developing a strong, persuasive case theory. Everything from witness statements to supporting documents should align to support that central narrative. When we do this well, it makes a significant difference in how persuasive our case will be during trial. Now we move into Phase 7, trial, which is arguably the most critical part of the litigation process. During the trial, each side presents their evidence and calls witnesses to testify, all in front of the court or jury. This step is essential because it's where the facts of the case are established and scrutinized. Trials can vary significantly in length. Some may last only a few days, while others can stretch over several months. The duration really depends on how complex the case is and how much evidence needs to be examined. After all the evidence has been presented and closing arguments made, the judge takes up to 90 days to issue a ruling. This period allows the judge to carefully review everything that's been presented and weigh the arguments thoroughly, ensuring a fair decision. It's also important to remember the burden of proof. The petitioner or plaintiff carries this responsibility to prove their claims. This is a crucial part of the trial because if they don't meet this burden, their case could fail, no matter how strong the evidence might seem at first glance. So, in summary, the trial is where the real battle for the case's outcome happens, with evidence, witness testimony, and careful judicial consideration all playing key roles in reaching a fair resolution. Once a ruling has been made, the losing party might choose to appeal the decision. It's important to remember that appeals need to be filed promptly because there are strict deadlines that must be met. The appellate process itself can be quite lengthy, often taking years to reach a conclusion. This extended timeline can add layers of complexity to the case, making it more challenging to navigate. Additionally, pursuing an appeal can be very costly, sometimes reaching tens of thousands of dollars or more. These expenses can pose a significant financial burden on the parties involved. Overall, the appeal phase is a critical part of trust and estate litigation, but it requires careful consideration of timing, complexity, and costs. Now, as we wrap up, let's review the key takeaways from our comprehensive guide to trust and estate litigation. First, it all begins with a thorough initial investigation. This initial phase is crucial because it lays the groundwork for everything that follows, ensuring we understand the facts and identify potential issues early on. Next, every step in the litigation process requires careful legal guidance. Having a knowledgeable attorney by your side helps ensure that all actions taken are in line with legal standards and best practices. Timely action is also vital. Protecting your rights means acting promptly and meeting strict deadlines. Delays can lead to unnecessary complications or even weaken your case. Of course, navigating trust and estate litigation often involves complex legal challenges, so expert legal support is essential. This support helps you address difficulties effectively and strategically. And finally, we must remember that the process may extend to potential appeals. Preparing for this phase requires additional expertise and careful planning to strengthen your position if an appeal becomes necessary. All these points highlight how careful planning, legal expertise, and timely action are fundamental to successfully managing trust and estate disputes. Let's talk about how you can get in touch with Vincent M. Cassiano, Esquire, for expert legal support. On this slide, we highlight that Cassiano Law Firm offers a comprehensive guide to trust and estate litigation, emphasizing their belief that life should be enjoyed from one generation to the next. This core philosophy drives their dedication to providing exceptional legal services to clients facing complex estate issues. If you're interested in working with them, I encourage you to schedule a free 15-minute initial consultation with Attorney Cassiano. You can easily book your appointment using the provided link at calendly.com/CassianoLawFirm1/15-minute initial tell. For immediate contact, you can reach Vincent M. Cassiano by phone at 619-806-820. Additionally, visiting his website at CassianoLaw.com will give you more details about his services and expertise. Remember, if you're involved in a trust dispute, Vincent Cassiano is a certified legal specialist in estate planning, trust, and probate law. He offers expert guidance to help you resolve even the most complex legal matters effectively. So don't hesitate to reach out. Professional help is just a call or click away.